Taking it briefly and in turn, Area 1, the relevant case law, that particular part of Archbold provides some very useful background material containing the relevant statutes and case law which touch on this area. It's a useful reference point for some of the expected and some of the unexpected scenarios that can arise in everyday practice in this particular area. However, this presentation that I'm doing today is really geared to looking at the practicalities of making effective submissions to the jury that hit home and improve the prospects of the jury at resolving the facts in your favour. Area 5, tips for a good defence closing speech. So we've moved on to the third bite of the cherry. And this is really where most barristers do their first address to the jury. As I say, I find it quite rare that defence barristers make a first speech and a second speech. And it can be right at the end of the trial that they finally rise to their feet to present their submissions as to why the jury should be acquitted, why the jury should acquit the client of the charge they faced. The key tips in terms of a good defence opening speech, when you think about it, are fairly obvious, but so often in practice, these things simply don't happen for a variety of reasons. It is critically important right at almost at the start of the case, when you crack open the papers, to think, oh, well, that's a good point. Bag it, think about it, and use it for submissions at the end. Have a very clear vision as to what you see the way the case will go, so you can adopt that and gear your strategy accordingly. Failing to understand that a jury needs help at this stage, quite often an elementary mistake is to think that the jury simply understand everything. They have to reach a verdict. That's an enormous pressure, an enormous burden on them, and they are looking to you to help them out in terms of isolating the important pieces of evidence and making them sure that in evaluating that they can come to a correct verdict.